Good morning. Our next case is in re KS, and we will hear from the appellant.
Good morning. Mr. Chief Justice, Honorable Associate Justices, may it please the Court. My name is Patrick Kuchet, and I represent the appellant, Cumberland County Department of Social Services. My colleague, Ms. Michelle Lynch, represents the Guardian Ad Litem program. We will be splitting our time evenly today, and we are reserving 5 minutes for rebuttal. The case is before you today through a petition of discretionary review of the Court of Appeals ruling. We have raised 3 issues before the Court today, and I will be discussing the first 2. The first issue that we have raised before the Court is that the Court of Appeals erred in failing to conduct a true de novo review on the issue of neglect. The second issue is the Court of Appeals erred by considering evidence which was not presented to nor ruled upon by the trial court at the adjudication phase. Ms. Lynch will be addressing the issue of the trial court and the Court of Appeals erred in concluding the evidence in this case did not support a legal conclusion of neglect of the juvenile Kelly. Some procedural background of this case: the petition alleging neglect and dependency was filed on 29 May 2019. An amended petition was filed on 4 October 2019. The adjudication hearing was held on 14 November 2019, and the trial court dismissed the petitioner's claim of neglect, however adjudicated the juvenile Kelly to be dependent. At the adjudication hearing, the parties stipulated 2 facts, which were presented to the court for review and for proper determination of conclusion of law. Both the respondent mother and the Cumberland County Department of Social Services appealed the trial court's order. The Court of Appeals issued an opinion in December of 2020. The Court of Appeals reversed and remanded the dependency adjudication, but affirmed the dismissal of neglect. The Cumberland County Department of Social Services and the GAL filed a petition of discretionary review, which was granted by this court. The first issue today is that the Court of Appeals, we are contending that the Court of Appeals failed to conduct a true de novo review of the trial court's order. It is well established in case law that the determination of neglect under the Juvenile Code is a conclusion of law, and that conclusions of law are reviewed de novo. A de novo review means of new, that the Court of Appeals, the appellate court, is supposed to review the evidence and law without deference to the trial court's rulings. However, in this instance, the Court of Appeals made several references to the trial court's determination that the juvenile is not neglected. They made several statements about deferring to the trial court's reasoning, and also discussed that they are not able to reweigh the evidence that was presented to the trial court. We believe that this was an error. Well,
help me understand how we reconcile a couple of things, because my understanding of de novo review in the context of an order entered in a non-jury proceeding like this one is that de novo review means you look at the trial court's findings of fact and they either do or do not establish the legal principle that's at issue in the case. It's an either-or proposition. You look at the findings, they fall on one side or the other of the line. Is that your understanding of what's supposed to happen, or am I starting off on the wrong foot?
No, Your Honor, I do believe that, especially, although that's the definition of, to completely reweigh all the evidence, it's the definition from Black's Law Dictionary. However, case law has established that traditionally the Court of Appeals would defer to findings of fact made by the trial courts.
But once you have those findings, then it's up to the reviewing court, either the Court of Appeals or this court, to look at those findings and decide either yes, they establish neglect, or no, they don't.
Yes, and I would agree with that.
Well, we've got any number of cases that Mr. Diepenbrock has cited to us that says something along the lines of how much weight should be given to a finding of prior neglect. The trial court's got some discretion as to how much weight to give those findings. How do you reconcile that language, which appears in our cases, with a classic de novo review?
Yes, Your Honor. And I'd say that if If the only finding of fact was that the juvenile's siblings had been previously found to be abused and neglected, I think you could spend more time debating whether or not there's weight to that or not. However, in this case, there are several other findings in fact that include domestic violence, which occurred 3 weeks after this juvenile was born, that occurred in the presence of the other juveniles. I think that when you're looking into weight, it goes more towards the weight of the evidence. Here, there's not a single challenge finding of fact. So it's
And I understand that, but if the trial court is entitled in the course of making a determination as to whether there is neglect in a proceeding in which one of the pieces of evidence that's discussed in the trial court's finding is a finding that another child in the home was subject to neglect, and given that the cases say that the weight to be given to that finding is to some extent within the discretion of the trial court, how do we conduct a classic de novo review given that our cases give some discretion to the trial court? In other words, what's the analytical framework that we're supposed to use if both of those things are true?
Well, that does lead to some complications because on one hand, de novo in its classic form is reweighing everything, but case law has said that we do defer to the trial courts. I think the instance here is the fact that I feel our contention is that the Court of Appeals did not look at the findings of fact in totality at all and simply just deferred to the trial court's ruling. So the tough answer is what is the analytical reasoning of an appellate court here? However, I'd say that it just needs to go, pardon me, I think one of the determinative factors here is that the Court of Appeals opinion states that another court could have found neglect. And I think that kind of leads us to believe of, well, what did this Court of Appeals find? When they look at the totality of the findings of fact, does it support a conclusion of neglect? And it's our contention that if it does, then the Court of Appeals should determine that this child was neglected.
So when you say that the Court of Appeals did not perform a, quote, true de novo review, unquote, which was a depiction that fascinated me because I didn't understand quite what true meant, but I think I'm getting a better picture of it. Are you saying that the Court of Appeals was obligated to wipe the slate clean, figuratively speaking, and start from scratch, again another colloquialism, in terms of beginning its appellate review and was not authorized to therefore just decide that it was satisfied with what the trial court had done in terms of its determination that it could find one way or could have found another way if another trial court had had the case?
Justice Morgan, that is in fact our contention, that a true de novo review would in fact allow the appellate court to review the findings of fact and make its own determination as to whether or not a juvenile is neglected or dependent. I think that there is a lot of case law out there that defers to the findings of fact of the trial court, which I think that the appellate courts would still be bound to. But however, I think that the appellate court can look at the findings of fact in totality and determine if a child is neglected or dependent or abused on a de novo review.
So are you contending that there is a misapprehension of the law in terms of what the Court of Appeals did, or it was not a full de novo review when saying it wasn't true, a combination of those, or something else?
So it is our contention that it was a misapprehension of law, that there was no de novo review here. They simply deferred to the trial court's ruling. Our contention is that a de novo review does not allow deference to the trial court's ruling. In fact, specifically the definition of de novo, an appeal de novo, is that it does it without deference to the trial court's ruling. So,
is it possible, and that's perhaps not a wise phrase, let me put it this way. Are you saying that the Court of Appeals is not authorized, at least theoretically, to perform a de novo review by looking at what the trial court did, decide not to disturb it, and simply find that in a default standard way, that de novo review will be exercised by the Court of Appeals by looking at what the trial court did and said, as a court of appeals, we don't feel we need to do anything because we find that there was authorization for what the trial court did. Couldn't that suffice as de novo review?
Justice Morgan, I believe that that starts getting into abuse of discretion. You start looking into the trial court did, and was their decision founded? I believe that starts looking into an abuse of discretion standard more than a de novo standard. If the Court of Appeals is supposed to review conclusions of law in a de novo standard, then they are supposed to take it and make a decision without deferring to what the trial court has done. So I think if you start not disturbing a trial court's ruling because what they did could have happened, I believe that's looking more towards an abuse of discretion standard than a de novo review.
So we've got excuse me, Justice Morgan, were you?
I'm done.
Okay.
Yes, thank you, Chief.
Yes. So we've got, it seems to me, two questions that seem to arise. The stipulated finding, fact 10, says that at the time of the filing, that they did not have essential necessities, And then you have, without explanation, the trial court dismissing the neglect claim without explanation. Are you asking us to take finding of fact 10, did not have essential necessities, and say that is a showing on its face that there's support for the neglect claim? Or are we to send this back to the trial court and say, why did you dismiss the neglect claim? You didn't tell us. I mean, what are we to do?
So I believe that will be mostly covered by my colleague, Ms. Michelle Lynch. However, what I would say is that when you look at the facts in totality, you have a domestic violence incident occurring in the home in the presence of the other children, which are not allowed to be around the respondent father in this case. You have, they don't have essential necessities for this juvenile. You have the previous adjudications for abuse and neglect. You have the respondent father who's been convicted of felony child abuse being allowed around this juvenile. I think that that goes to a substantial risk of harm and shows that there's neglect in this matter. So I think that we need to, whether the Court of Appeals makes a determination that there is neglect based on the totality of the findings of fact, or the Court of Appeals were to send it back to the trial court for a reasoning, but I think it'd be better for the Court of Appeals to make a true de novo review and make a finding, make a conclusion of whether or not this juvenile is neglected.
Well, I had understood that you were asking us to find neglect as a matter of law here. Is that wrong?
We are asking that the Supreme Court reverse the Court of Appeals ruling and find neglect in this matter. We think that the findings of fact as stated in here rise to the level of the definition of neglect.
And to follow up on the Chief Justice's question, how would, if you were to write our opinion to say that consistently with the cases that you and I discussed earlier, how should we do that?
So I think wording it is a matter of conducting a true de novo review, looking through the record, looking through the findings of fact. The findings of fact contained in the order rise to the conclusion that this juvenile is neglected. I think that is proper, and I don't think that neglects any precedent or that has been handed down by this court previously. I think that if we were asking to disturb several findings of fact, asking the court to overturn several conclusions of law and asking court to reweigh evidence, I think then we may start going into the problems with In Re JAM, where where the Court of Appeals is to give deference to the trial court. Here, there's not a single contested finding of fact, which I believe allows the court to make a de novo review without upsetting any of the precedents in this court. And, Your Honor, I am cutting into my colleague's time. If there are no further questions, I will turn it over to her. Thank you.
May it please the Court, Chief Justice Newby and Associate Justices, I'm Michelle Formative Lynch, and I represent guardian ad litem for the child. And just to speak briefly to what Mr. Cutchett was talking about, in this case, the mother does argue that the trial judge has discretion to weigh the factors, and that is correct. And in most cases, there's some evidence of how it weighed those factors. But in this case, there is no indication of what factors the trial court weighed more heavily in their determination. And what we would submit is, in a true de novo review, you will look at these factors and determine as a matter of law if they constitute neglect. One of the most important points here is every finding in fact supports an adjudication of neglect. There's not any finding that does not point towards neglect in this case.
Well, let me ask you, I understand your argument, and that makes sense to me. And this is kind of to follow up on what a couple of my colleagues were asking about what this review would look like if the Court of Appeals did a true de novo review. That none of the findings of fact have been challenged, so they're standing, and you look to see whether they all add up to to a conclusion of neglect, correct? And that the Court of Appeals would do that all brand new and would identify those factors and say whether they add up based on the findings that are unchallenged to neglect or not. And when I'm looking at the Court of Appeals opinion, I'm on page 13 where the Court of Appeals says that evidence of prior abuse standing alone is not sufficient to support an adjudication of neglect, that instead we require the presence of other factors. I thought they were going to go on and discuss the other factors and what would lead them to a conclusion of neglect or not, but they didn't.
No, they didn't, and there were many factors that they did not discuss.
Is that the main problem with or is that one of the main problems with the review conducted by the Court of Appeals?
That is one of the main problems, because there are many cases that talk about when there's a history of past abuse and neglect, usually there has to be at least one other factor to conclude that an infant or newborn is neglected. There are cases that list many factors that go into the determination. And some of the cases only list 2, but in this case we had at least 6 factors that the court really should have reviewed and looked at the totality as to whether all these factors together constituted neglect. And I would submit that the first error that happened in this case was in the trial court, because the mother argued that an infant could not be adjudicated neglected because it had not been in the custody of the parents. She argued Kelly has not been in the custody of the parents. It's not been an injurious environment. It was not the one exposed to the domestic violence. So, Judge, this child is not neglected. And the trial court agreed with the mother. And that is why it did not find neglect. I think it's page 18 in the transcript. The court agreed this child's not been in an injurious environment, which totally neglected all the case law that says when you have an infant, your determination is more predictive risk. You have to look at the historical facts and determine, is this child at substantial risk of harm, of future abuse and neglect? And we would submit, when you look at all the factors in this case, to us, it is unbelievable that there would not be neglect, because just as Justice Newby said, just the one factor of lacking essential necessities means that the parents were admitting they could not properly care for their child. That constitutes neglect. So beyond the factors in this case of past abuse and neglect and domestic violence, the factors, this all is contained in the findings of fact. All 3 older children were still placed outside the home, which indicated the parents had not corrected the conditions which led to their removal. The parents had defied a court order when they placed the oldest child, April, in the presence of the father who abused her. The father had a past conviction of felony child abuse of April. And just after Kelly was born, he threatened to bite April in the car where he was not supposed to be around the child. This contributed to the domestic violence and the mother driving like a maniac, and this is in those findings of fact, which put the child and the parents all at risk. Finally, as we discussed, the parents' admission that they did not have essential necessities for the infants indicates they didn't have housing, food, or clothing. Therefore, they were not in a position to take care of this child.
Can I just ask a question? In your view, was the trial court's adjudication of neglect supposed to be based on the conditions at the time the petition was filed or at the time of the hearing?
The purpose of the adjudication is to determine the facts, whether as they exist in the petition. So yes, it goes to the petition, but we would submit that the conditions at the hearing were contained in those findings of fact, because that was the only evidence put in. And I know the mother has argued the court should have looked at current conditions. Well, those were the current conditions. The mother did not seek to enter any evidence of current conditions at the adjudication hearing. You know, just like in another case, was there any offer of proof? No. So what conditions she mentions that might have been brought up, no one knows.
Right, but she didn't have the burden of proof.
She didn't have the burden of proof, but she could have submitted evidence. But she stipulated and admitted to these findings of fact. So I would take that as she stipulated that those are the conditions at the time of the hearing, because she stipulated to them in the hearing.
Right, but it was very clear that they stipulated to those facts, but they wanted to argue about whether or not they actually constituted grounds for neglect, right?
That's correct, and that is because the mother's attorney mistakenly told the judge that this child could not be adjudicated neglected because it was not in the custody of the parents at any time. She indicated that only if the parents had custody could this child be adjudicated neglected, and the trial court went with that.
So if that's what the transcript reveals happened at the trial court level, then is it fair to say that what's supposed to happen at the appellate level is a de novo review of a finding of no neglect, or is it actually a review? It does seem that the
Penal factors of a conviction of child abuse, defiance of a court order, domestic violence, the father's threat to harm the oldest child, and lack of necessities. So when you look at the precedent, it's really hard to determine why the trial court or the Court of Appeals would not find that this did not, as a matter of law, constitute neglect. The only thing I can say is that the mother convinced the trial court that it just wasn't possible in this case because it was an infant and had not been in the custody of the parents. And the Court of Appeals mistakenly did not conduct a true de novo review where they should have looked at all the factors. And I don't think it was necessary for them to know the weight of each factor because it was not evident from the transcript, because there was no testimony, there were no witnesses, there were just these stipulated facts.
Did deference to the trial court have any place here at all?
I'm sorry?
Did deference that was paid to the trial court have any place in the Court of Appeals review of this matter at all?
In this case, when you do not have any witnesses where a judge is looking at the candor with the court, their demeanor, their trustworthiness, all those things are always mentioned in cases where the appellate court defers to the trial court. And in this case, when you just have straight out facts that everyone agrees to, I do not believe that the court needed to defer to the trial court.
Is that the misapprehension of the law here that it sounds like your colleague was stating existed?
Yes, because the court actually said, well, one court could have found neglect under these facts, but we can't. We're going to defer to the trial court. And I'm moving into our rebuttal time, so thank you.
Thank you, counsel. We'll hear from the appellee.
May it please the Court, Chief Justice, Newby, and Associate Justices, I am J. Thomas Diepenbrock of the Buncombe County Bar. I represent Appellee Respondent Mother Kayla Jeffcoat. With all due respect to my friends on the other side, the position of Appellant's Department of Social Services and guardian ad litem in this case runs contrary to the statute 7B 101-15, which states that prior neglect or abuse of another child in the home is relevant to the determination whether a child is neglected, but which does not mandate a conclusion of neglect. It runs contrary to the principle announced by the court in In re Nicholson in 1994 and followed by the appellate courts of this state since, that the statute gives the trial court some discretion in determining the weight of such evidence.
Well, let me try with the question I ask on your colleagues on you and see what answer I get. I mean, typically, it's also pretty clear in the cases, one, that whether a juvenile is neglected or not is a conclusion of law. I mean, you don't, I take it, disagree with that.
Yes.
Conclusions of law on appeal are subject to de novo review.
Correct.
Typically, what that means is that you look at whatever the properly supported findings of fact are, and you determine on appeal whether those findings do or do not, as a matter of law, establish neglect. Typically, is that correct? How do we, given that we've got a conclusion of law here, given that that's typically what it means to engage in de novo review, how should the court consider in conducting de novo review the cases that you've directed our attention to that say that the trial court has some discretion in terms of weighing the prior adjudication component of that?
I think it's perhaps confusing or unhelpful to focus on this idea of pure de novo review where no deference whatsoever is paid to the trial court's determination because...
Typically that's true, though, isn't it?
I think it may be true. I mean, but I'm focusing on this case and the cases
and ultimately
that
that's
we've
what we
cited.
need to do. Right.
I would say it's a modified de novo review because looking at these cases, there will be a recounting of the trial court's findings of fact. There's citation of law, including the statute, 101-15, and including the statement that, and statements that run throughout these cases that the trial court has some discretion in determining the weight to place on prior adjudication and some discretion in really arriving at the conclusion of whether the child is neglected based on the environment, the age of the child. So it's not a straight up, pure de novo review.
Is it your contention that it's an abuse of discretion review?
No, it is not an abuse of discretion standard because the decision isn't entirely within the discretion of the trial court, but the trial court has been given by the statute as interpreted by these cases since 1994 some ability to place weight on the prior adjudication, prior evidence of abuse or neglect, as well as the other factors in the case before it.
So since we are dealing with the question of what is the appropriate method for an appellate court to review an order like this, if the fact that you've got a prior adjudication doesn't create abuse of neglect, abuse of discretion review in this context, how should an appellate court go about determining whether the trial court's findings in a case in which there is a prior adjudication of neglect establish neglect?
I think the trial, or the appellate court has to look at what the appellate, or what the trial court did. And so the appellate court, did the trial court recognize that a prior adjudication of abuse or neglect is relevant? Did the trial court place weight on that factor? What weight did the trial court place on any other factors before it? And so it is.
Well, how would we do that in this case? I mean, we've got, at least if I understand the order, we've got a finding that there was a prior neglect. We've got a finding that, at least as of the date of the filing of the petition, the mother acknowledged that the parents didn't have enough of the necessities of life. You've got a mother allowing another child to be in the presence of a father in violation of a court order, and you've got domestic violence between the parents in front of another child. So it's not like we've got just a case in which there's a prior adjudication of neglect and nothing else. We've got these other factors in addition to that. How do we conduct a review in a situation like that?
Well, I don't know that this court, I know that appellants are asking this court to conduct its own de novo review and find neglect on these facts. But I think that what the Court of Appeal did was to recognize that the trial court has some discretion in making this determination, and to also, I think, correctly recognize that these facts don't compel a conclusion of neglect, and giving some discretion to the trial court to place weight on the factor of the prior abuse, neglect, adjudications, as well as the other factors that were reflected in the stipulated findings of fact.
Well, hypothetically, if the facts of this case were no prior adjudication of neglect at all, none, but we have domestic violence in front of one of the children in the family, absence of ability to provide necessaries of life, and one of the parents allowing the other parent to be in the presence of one of the children, not the one that's the subject of the petition, but another one, in violation of a court order, would that show neglect?
I would say that the facts by themselves do not, again, compel a conclusion of neglect. They're just.
When you say it doesn't compel it, that suggests to me that you're saying it might or it might not. In other words, that there is not a conclusive determination of law one way or the other. Is that what you're saying?
I think that is what I'm saying.
How is that reconcilable with the traditional understanding of de novo review? Are our cases that say that findings of neglect are subject to de novo review of those decisions incorrect?
I think the de novo review in this case has to include both the statute and the case law that has followed it that gives the trial court some discretion. So the Court of Appeal is looking at findings of fact. In this case, there was no challenge, of course, to the findings of fact because they were stipulated. And the conclusion that the trial court made that there was no neglect, and hence he dismissed it. And so the de novo review has to contemplate and incorporate what the statute says and what the case law says, that there is some amount of discretion given to the trial court. And so the appellate courts shouldn't have to scrutinize to that level every time a trial court has made a conclusion of either finding neglect or not finding neglect.
So let me see if I can understand your argument a little bit better. By discretion, in reaching conclusions based on unchallenged findings of fact, a lot of times you'll see that there are some findings of fact that point in the direction of neglect and maybe some that don't, that would indicate that the parents are making progress or what have you, and that the trial court, in deciding whether to reach a conclusion of neglect or not, would take the ones that point toward neglect and the ones that point in the other direction and see what they add up to in the court's view. But my question is here, given that all of the findings of fact are unchallenged, can you point to any of the findings of fact as indicating that there's not neglect here?
Well, there's some background findings of fact, so those, those don't necessarily point to neglect.
But you're not disputing the argument by the other attorneys that there are several other factors, including the ones that Justice Ervin just mentioned, the violation of the court order and the presence of domestic violence, even without just the prior neglect, that there are other factors that would tend to show neglect.
They could. I mean, I just wanted to make one comment on the lack of necessities at the time of the filing of the original petition. I'm not sure that really does much to show neglect, because there was an amended petition that was filed months later, and I think that finding really goes more to the dependency that the court the trial court ultimately found.
Well, another thing is that you're not disagreeing, are you, with the argument that it can't be neglect because the child was an infant?
Yeah, I would say that was not a correct statement of the law, because that would ignore the case law that says that there can be a substantial risk of harm in the situation where a child is not with his or her parent.
But aside from that, are there any other particular findings that you would point to as helping to add up to the conclusion that there was no neglect here?
I can't think of any.
Okay,
I'd have to go back and look, but nothing comes to mind.
okay.
When you were addressing my learned colleague, Justice Ervin, earlier, you employed the term, quote, modified de novo review, as I recall it, unquote. In employing that phrase, are you in fact agreeing with the other side that there was no, quote, true de novo review, unquote, employed here, but you feel as though that wasn't necessary because deference can be accorded to a trial court properly in a de novo review exercise as here by the Court of Appeals?
Yes, I would agree. I would agree with that it's a de novo review, but it's not, if de novo review is defined as giving no deference whatsoever to the trial court's conclusion based on the findings of fact, then no, I would submit that the statute and the case law really makes it clear that that kind of de novo review defined that way is not the correct standard of review. So it's de novo review that has to contemplate some discretion being given to the trial court to weigh the different factors, including any prior adjudication of abuse or neglect.
Would that be inherent in every case, or are you saying that that would apply here in light of the fact that where there is a previous adjudication of neglect, that a trial court is given deference as to how much weight to give that in terms of the kind of non-secure custody of an infant that was taken here?
Yes, I think that is right. In this case, not across the board. for all instances of de novo review or all instances of do the findings of fact support the conclusion of law. But particularly in this instance where we have a statute that makes it relevant, doesn't mandate a conclusion of neglect based on the prior adjudication of abuse or neglect, and case law that has consistently repeated Court of Appeal, Supreme Court, that the trial court has some discretion, and that discretion doesn't just go away because we're operating under a stipulated set of facts. I mean, as I've looked at these cases, typically the Court of Appeal or the Supreme Court will acknowledge findings of fact made by the trial court. Sometimes there's a challenge, sometimes there isn't as to those findings of fact, but then based on those findings of fact, there is the question whether the findings amount to or support or don't support a conclusion of neglect. And in this particular circumstance, the statute is clear, the cases are clear that the trial court has some discretion.
I want to ask you, apart from the discretion that the trial court might have to weigh the evidence of the prior neglect in the case of an infant, if it is true that the Court of Appeal should exercise de novo review over any legal conclusions that the trial court was operating under, correct?
Yes, correct, but also contemplating that maybe I'm misunderstanding the question.
Well, so I don't want to say, maybe not legal conclusions. If the trial court was operating under the misapprehension that in order to make a finding of neglect, there had to be conduct directed at the infant, so the baby had to be in the parent's custody and then be neglected. If the trial court was misunderstanding the law, then de novo review would require a correction of that, right? You wouldn't defer to the trial court's understanding of the law.
No, but I would say that just the fact that respondent mother's trial lawyer made an argument doesn't translate to that the trial court accepted that legal premise or that argument. I mean, all we know is she made an argument and the trial court concluded that there was no neglect, that the facts, stipulated facts, didn't rise to the level of neglect, I think is what the trial judge said.
So,
I'm sorry.
no, go ahead.
In its order, one of the things that makes the review a little tricky is that the court does not explain why it dismissed the claim for neglect. It quotes all the stipulated findings and accepts the stipulations and admissions of the mother and finds that there's dependency and then just dismisses the claim for neglect without further explanation.
That's true. There was no explanation. There was no, and I think it's significant to note that there was no ultimate finding of fact that this child was at substantial risk of harm should he be returned to his mother's custody. That was something that really needed to be in there to support the conclusion of neglect. And so the fact that the parties chose to go forward with these stipulated facts, I mean, I guess it could work both ways. I mean, my colleague mentioned that respondent mother could have introduced evidence, but by the same token, the department and the guardian could have introduced evidence as well to support their position that this was neglect. I do think it is correct, though, when the Court of Appeal was accurate to say that these facts do not compel a conclusion of neglect. It's not like there's only one outcome that can be arrived from these stipulated set of facts. I think it's just as valid to say these stipulated facts do support a conclusion that there was no neglect. So,
Well, make that argument for me then. Why do you, assuming that all the things that in the stipulated facts are true, why do they not show neglect?
We have the finding of fact 10 that the Chief Justice referred to. I think that really goes more to what the conditions were at the time of the original petition, doesn't go to whether they lack necessities at the time of the amended petition. So I would say that fact by itself doesn't go very far towards showing neglect at the time of the amended petition. So
Before you go much further than that, it says above in finding of fact, or above the neglect finding 14, it says in 10, it says, social worker testified and verified that the above factual allegations were true and accurate to the best of her knowledge, and the above facts existed at the time of the filing of the amended petition.
okay. Your Honor, I'm sorry, where are you
This
reading?
is finding of fact 10, and finding of fact 11 says that the respondent mother as well, as sworn testimony of the social worker, verifies the above facts.
Okay, so we have stipulated fact number 10, and then we have finding of fact number 10. I think that's why I'm getting a little mixed up. Well, perhaps that would help someone to add that particular finding of a fact as a potential reason or basis for a neglect conclusion. But I guess I'm going to just keep harping away that the facts are, there's not a lot of facts. There's a few facts, really. I mean, there's a number of facts, but they don't mandate that the trial court had to find neglect under these particular facts. The trial court had the facts before them, heard the arguments, and concluded that yes to dependency, but no to neglect. And so, once again, giving the trial court the discretion that the statute gives and that the case law has reaffirmed since then, that discretion, it was correct for the Court of Appeal to say we can't say as a matter of law that the trial court erred by dismissing the neglect. So in response to some of these questions, it really isn't a situation of quote-unquote classic de novo review or pure de novo review. So we asked the court, I was kind of in the middle of talking about how the position advocated by the appellants is contrary to several different things. The principle, the statute, the principle announced in Nicholson, and all the cases that have cited it since then, the principle that inherent in Nicholson and cited by other cases, that the trial court has some discretion as well to determine whether children are at risk for a particular kind of harm given their age and the environment. That was stated in McLean, citing Nicholson, and it's contrary to the role of trial judges in making judicial determinations, particularly in this particular context. And contrary to the role of appellate courts in reviewing determinations and legal conclusions made by trial court judges, and specifically the determination whether a child is a neglected juvenile. So we would ask this court, rather than adopting appellant's position, to adhere to existing precedent, which holds that Section 107B 10115 allows the trial courts in this state some discretion in determining what weight to assign to a prior adjudication of abuse or neglect, and some discretion in determining, based on the factors of the case before them, whether a child is at substantial risk for future harm. Applying the statute and the existing precedent to this case should lead to the conclusion that the Court of Appeals correctly affirmed the determination of the trial court that the stipulated facts did not support DSS's claim that Kelly was a neglected juvenile. Said another way, and I've said this, the risk of repeating myself, the statute and existing precedent shows the Court of Appeals correctly held that stipulated facts do not compel a conclusion that Kelly was neglected. If the legislature wanted to take all judgment from the trial courts in these cases, it could have included in the statutory definition of neglect that a prior adjudication of abuse or neglect of another child in the home requires a trial court to conclude the child is neglected, but the legislature has not done so after many years of litigation.
Can I ask you about a different factual matter? The Court of Appeals references, somewhat in passing, but references that the father, seems to say there shouldn't be a lot of weight put on the facts that were stipulated to about the incident that occurred in the car after, this was in the amended petition, happened after the first petition had been filed, in part because the father was no longer in the state. And as I understand DSS's response, they say, well, that's not really in the record. But the counsel's representations about, counsel for the father came to the hearing and was dismissed because of his statements about where the father was. So is that proper for the Court of Appeals to give some weight to what counsel says about where his client was?
I would say that the fact that the Court of Appeal referenced the information wasn't essential to its decision, because there's nothing to indicate that the trial court considered that when making its determination. It's not included in the trial court's findings of fact that were based on the stipulated facts. But it is ironic in some ways that the appellants raise the issue, because there's references throughout the record to the father's location in Florida. There's, without rattling them off, there's at least 5 different references to the father being in Florida, trying to be served in Florida, specific address in Florida. The DSS lawyer told the trial court that the DSS tried to serve the father in Florida. So it appears clear from the record that the trial court and all the parties knew that the father was in Florida. But again, there's no indication that the trial court took that into consideration. So the fact that the Court of Appeal referenced it was really not essential to the Court of Appeal's decision. So in conclusion, it looks like I'm out of time. Chief Justice and Associate Justices, thank you for your time and careful consideration. We ask that the court either affirm the decision of the Court of Appeals or alternatively, consider making an order that review was improvidently granted since the Court of Appeals decision was correct and grounds for discretionary review are not present. Thank you.
Thank you, counsel. Rebuttal.
May it please the court. Your Honors, we are not asking the Court of Appeals or this court to compel the trial court to make a finding. We're just asking that a de novo review occur and that the trial court or that the appellate courts review and decide whether or not the findings of fact meet neglect. And part of the reason I was thankful that Justice Earls brought up the Florida discussion in the Court of Appeals opinion. The Court of Appeals mentions that the domestic violence incident between the parents should be kind of discounted by the trial court because the respondent father's in Florida now. That evidence was not presented at adjudication, and in fact, there was never any evidence presented of that at all. Statements of counsel are not evidence. They was not sworn in. They were not subject to cross-examination. It was not testimony. Also, it's that there's a belief that he's in Florida. He was never served in Florida. So even if the court were to consider that, I would argue that it's not even competent because there's no actual proof that he was in Florida other than word of mouth. He was never served there. And in fact, the social worker said that they'd had no contact. And furthermore, once the only mention of, on the day of the hearing, the only mention of Florida was in the court report provided at disposition. So even if it's determined that he was in Florida, that evidence was not presented at adjudication. So this kind of illustrates the fact that, yes, the Court of Appeals is saying we have to give deference to the findings of the trial court. However, we're also going to find that this guy was in Florida. The respondent father was in Florida. So the domestic violence really isn't that big of an issue. To me, that is reweighing the evidence. That is conducting the start of a conduction of a de novo appeal. And Justice Hudson, we are in line with your thinking that once they started to discuss the neglect and talk about the prior adjudications, we expected the opinion to continue to go through the other factors, the domestic violence, the prior felony child abuse convictions for the respondent father, but that was never done. In fact, the court just relies on the trial court's findings and conclusions of law. And it is our contention that the dismissal of neglect is a conclusion of law that the juvenile did not meet the definition of neglect. So it would be our contention that that is a dismissal is the equivalent of a conclusion of law that the juvenile is not neglected. So we're just asking for a proper de novo review. If the Court of Appeals sees these findings of fact and then determines that there's no neglect, that's a de novo review, and that's perfectly sound and reasonable according to the standards put forth by this court, that conclusions of law are reviewed de novo on appeal. So if the Court of Appeals in their opinion had stated, we see these findings of fact, we have looked at them, we have weighed them, we still find that there is no neglect, that Kelly is not neglected juvenile, that would be improper and in line with the de novo review. So that is our position on today's date, that is how the Court of Appeals should have handled this matter. I believe my co-counsel also has some points to point out regarding the findings of fact, so I will leave time for her unless there are any questions. Thank you, Your Honors.
May it please the court, I just want to make a couple of points. We believe that the findings of fact in this case do compel a finding of neglect for a newborn child. In all the cases of abuse and neglect, when you're looking at a newborn or infant, all the cases seem to focus on whether there are evidence of changed conditions. Have the parents worked and created an environment that won't be injurious to their child? In this case, you did not get that. Also, you have to look at the age of the child and the particular kind of harm. In this case, you do have an infant, and the prior abuse was of an infant. Finally, by reversing the Court of Appeals on this, you will set precedent to ensure infants, the most vulnerable of any children, are protected in cases such as this, where there is overwhelming evidence of the risk of abuse or neglect. Thank you.
Thank you, counsel. Thank you to everyone. Madam Clerk.